sorry, we have to wait.
We are going live.
Okay,
Well said.
so now we're back in the air. So good morning. It is Wednesday, February 14th, 2024. Meeting Senate Natural Resources and Energy. And we're reviewing the next draft of Bill S213. This one is draft 4.1.
I said,
It is time stamped 2/13/24, 1:31 p.m. Okay, back to Mr. O'Grady.
So this is my grade, us, as the council, I'm gonna walk through the changes that were made yesterday. The draft 3.1, the first change is on page 3. In the policy section for netting of wetlands. There was previously language regarding the impact on wetlands, and everywhere else the term that was used is adversely affected. So it's being changed from to be achieved through protection of existing wetlands and restoration of wetlands that were previously adversely affected.
Right.
And then you see some change on page 3, line 19. Instead of impact wetlands from impacts, it impact wetlands from adverse effects. We can go to page 9. Line 13, section 6 is the appropriation for the wetlands program. Yesterday you had 750,005 new positions. Now it's 300,000 new positions.
And I think with Ms. Smith, so that's based on your recalculations. Excuse me.
for the record, this is Kim Smith. I think that this secretary's proposal that was walked through by Julie Moore several weeks ago had identified 5 FTEs for the program. I think that this is a decision for the committee. I know that the 5 FTEs was based on a general assessment of the needs related to mapping. I don't have more information on that at this point.
Okay, so my recollection was that we were trying to adhere to recommendation of the administration on this, and that's why we changed it.
Yeah.
When you all have a chance to revisit 4.1 and have any discussions back in the agency, it's like inadequate resource for the tasks that are now spelled out here. If you could let us know, because at this point it's all a suggestion that will bring to appropriations.
Okay.
Okay.
The bottom of page 9 is just a clarification that when DEC amends the statewide river corridor base map, they will do so by procedure. And then on page 10, this is the language that yesterday had referred to infill and designated areas. Now it's areas suitable for development that are located within existing settlements and that will not cause or contribute to increases in fluvial erosion passage.
Any concern, questions? So yeah, that's for folks representing themselves and or others. If you see something, don't be shy about raising your hand or calling out if I missed your hand. Thank you.
Okay, moving on to page 11. You're moving into the river corridor area language. And yesterday the draft had struck any authority or reference to development exempt for municipal regulation. But as Rob and others referenced yesterday, you want to keep that because that's how the state maintains NFIP eligibility for those uses that are exempt from municipal regulation. The first change is to change it from uses exempt from municipal regulation to development exempt from municipal regulation. That's actually a very harder rule. applies to development exempt from municipal regulations. So that first change is being in paper, line 17.
So we're aligning with the NFLP program, right, and the, as a use and staff is developed.
And then you'll see in the directive to the agency department to do rulemaking. First change is on page 12, line 20 and 21, on or before July 1, 2027, so the date changed. And after consultation with ACCD and the regional planning commissions, which you asked that language to be moved here, shall adopt rules that establish requirements for issuing and enforcing permits for all development within the map river corridor. So that's what you requested, but also for development exempt from municipal regulation and flood hazard areas. Because you're gonna need that state regulation in order to maintain NFIP eligibility.
Right.
And so that, then you look at the rulemaking, page 13, lines 8 through the bottom of the page. They're still gonna set forth requirements for development that's exempt from municipal regulation in a flood hazard area. Because they need to do that, and they still need to design these rules to ensure that the state and municipalities meet community eligibility requirements for NFIP. But then they're gonna establish requirements for the permitting of development within the map river corridors of the state. And provide 17 through 19, this is the language that Mason and Overstreet recommended, provide certain regulatory exemptions for minor development activities in map river corridors. The development activities have no adverse environmental effects. And then they will establish requirements. This is a question for you, for a municipality to be delegated the state's permitting authority for development in a map river corridor. When the development is not exempt from municipal regulation. And when the municipality has adopted what? Because later on, you take away their ability to adopt river corridor ordinances. Because A&R is regulated.
A&R takes it over.
Right. So are you even having delegation, or do you just want to change a river corridor ordinance to a bylaw or ordinance under 24 VSA chapter 117 that's been approved?
Exactly.
But that sounds like, well, that's the current situation, yes?
Yeah.
By law.
Yes, you could do a bylaw or ordinance. Still gonna be a little bit confusing because you are taking away their ability to do river corridor ordinances.
But is this bridge language?
Yes,
What do you mean bridge language?
Well, until the state takes it over.
or they issued a rule, right? So they could in the rule specify what the delegation requirements are, because that's establishing requirements and process for municipality to be delegated. Maybe it shouldn't be a bylaw or ordinance, maybe when the municipality has adopted provisions that have been approved by, but I think for the time being, bylaw or ordinance is gonna be sufficient. But I just wanna flag that if you're still contemplating state delegation, you have to figure out what's gonna trigger that.
So my sense is that until the state would take over, that we're maintaining the status quo. So because aren't there 10% of towns that have bylaws for the border development right now? So we want to preserve that until there's another program in its place.
Sure.
And then the rules could specify whether or not you can get delegated going after that years.
Okay.
Okay, so maybe you go to your suggested language of bylaws.
Okay.
Okay.
And then on page 14, lines 5 through 6. This is setting forth, it's going to set forth the process for amending the statewide river corridor based map. Yesterday, this language had the consultation language with ACCD and the regional planning commissions, et cetera, et cetera. That language has been moved. to two different places, and so, but you still want them to have a process in the rules for amending the recorded case map. Page 14, line 9 through 10, that's really just a conforming amendment to, its development exempt from municipal regulation and when they are in flood hazard areas. And then that's seen, or actually page 15, line 12. The date change for when the permit's gonna be required, it had been July 1, 2028, it's now January 1, 2028. Person shall not commence or conduct development except for municipal regulation in a flood hazard area or any development in a map river corridor without a permit issued under the rules required through subsection F.
Great.
All right, moving on. Page 16, I have a question for you and maybe for the agency. Currently, there is authority in statute to delegate part of the river corridor permitting programs to another state agency. Do you want that to be retained?
I think the agency would support leaving that in there.
Okay. All
For
right,
examples of Metron, which they do.
Right, if V-Trans wants to do this, they're welcome to it. It's-
okay. So I'm gonna step that. On to page 17, section 10. This is the state flood hazard area standards. This is where there was some confusion yesterday about how going to be implemented and when, and what municipalities need to do. So first, the thing, I had a discussion with the chair yesterday afternoon, page 17, lines 14 through 16. The first directive is that on or before January 1, 2026, A&R shall adopt rules that establish a set of flood hazard area standards for enrollment in the flood insurance program. Okay, so rules that set standards, the rules can exceed, shall exceed the minimum standards for NFIP. Ensuring new development does not create adverse impacts to adjacent pre-existing development. And then you go to page 18, line 2. So yesterday there was a lot of,
I'm sorry. This is Hannah Smith, on line 17, and this isn't flagged as a change, but I had, what page? Sorry, 17 on 17. I had thought the language previously read standards that meet or exceed minimum standards, so that IP.
I think it's always been exceed, but meet or exceed would probably be reasonable.
I think agency would like that.
Yeah, sure, why not? It's inspect.
The intention is to update the standards currently in the flood hazard area rule, and then it will exceed the NFIP standards, but I would like that flexibility.
Okay, so line 17, that exceed becomes that meet or exceed. Okay. Great, thank you for that.
So yesterday there, the language directed the municipalities, required them, mandatory, that take their bylaws or to incorporate the state flood hazard areas. Now it's just discretionary. So they may take their bylaw or to incorporate state flood hazard areas. However, on or after January 1, 2028, the state flood hazard areas adopted by rule by AMR shall be the state minimum flood hazard area standards. And that means when FEMA reviews municipal compliance with NFIP, FEMA is going to look to see if that municipality is complying with the state minimum flood hazard area standards. And that ultimately requires the municipality to come into compliance with those minimum state hazards. So there's no directive for them to do it by a certain time, but over time, with FEMA review, all municipalities will have to come up to those state minimum standards.
And that was the workaround to making the state a regulatory agency. It seems like the strongest motivator for meeting flood hazard, for enacting flood hazard bylaws is that it makes your municipality eligible. And so we're advancing what the minimum is, maintain eligibility, you need to say, a FEMA requirement is that you be in compliance with your state flood hazard minimums. And if you're not, it will be FEMA that will be talking to post 2028. You're gonna need to make changes in order to stay in our program.
I think I understand that hook for the towns who want to maintain eligibility. I wonder if under page 18, line 2, it should still say shall regardless, because the objective is to get towns to phase this in and understand the minimum flood hazard area standard before FEMA comes knocking.
So where would you put the shall, Ethan?
So
So here's line 2.
So what,
Put it 2 versus.
this was a solution to this jam, and the reason we were with may rather than shall was, at least in my mind, was if the state doesn't want to put itself into a position to enforce the permissive language, sort of properly passes us back to a municipal decision to be in or out of the program. I agree that I would think every municipality would want to make the move. But I thought one of the concerns for A&R was that a shall then made you also an enforcer.
Frankly, I don't think we have the authority to enforce this, so the shall is intended to. I understand what you're saying. We don't have the authority to enforce it. The regional planning commissions can enforce updated bylaws. So the NFIP eligibility is clearly the best motivator.
Yeah.
I think that the use of shall would indicate a directive.
More transparent.
Yeah,
I'm fine. I mean, that's what we're anticipating. We're saying there's a problem. People need to move to a better standard, and also, as I understand it, life at A&R, a lot more straightforward because people are moving to the same standard as opposed to perhaps 274 unique flood hazard area plans.
right. And the technical assistance that the flood management program provides will, as this rule is adopted, it will conform with the requirements of the rule. They'll be providing the permitting materials that are consistent with the rule.
Yeah, Senator McDowell, I'm reading your face. I think you want to go to shall.
I just. I'm asking myself, what are the regional PCs, planning commissions enforcing for? What's the track record of enforcement?
Well, we have one member of RPC on our Zoom with us, Mr. Campany. Can you speak just briefly to the enforcement role that an RPC does or does not play related to adoption of municipal flood hazard plans?
So, Chris Campany, Wyndham Regional Commission, we have no statutory or other authority to enforce municipal flood hazard regulation. The only role we would play might be fielding questions from floodplain administrators about how they might proceed with an issue, providing technical advice. The big caveat to that is always that whenever it comes to a legal decision, we always urge the towns to consult with the town attorney, because we are not attorneys.
Sure.
So they wave their fingers at them when they're not doing it. So, do you give a very strong finger wave when they don't?
No, I mean, our role with towns is inherently collaborative. We don't shame them into doing something or not doing something. We try to proactively provide training for floodplain administrators. But generally we're here at their request to provide advice on issues that they're dealing with, but it doesn't work. Our role is to support towns and what their needs are, we have no capacity to shame them into doing something, nor would it be productive.
Yeah, so I understand your point. The only party with real leverage in this, all these relationships is FEMA. And then they offer an FIP if you have such violence. So let's say shall, because that is really clearly the intent of the bill. And move over, and leave the FEMA leveraged relationship intact as it is.
Who's the Secretary of State that said we fight the war with the army we have?
Couldn't tell you.
Hmm?
Couldn't tell you.
Got the wrong phone today, so I can't look it up. But I think it was Rumsfeld. Pardon? I think it was not state, but defense. Yeah, it was the Secretary of Defense, it was Rumsfeld.
All right.
Rumsfeld.
So shall,
Shall, we're gonna have to march on like Sherman. Here we go. Line.
okay. So going on to page 19. Before I go into these sections, these are the conforming sections, so.
I wasn't endorsing the notion that you fight with what you have, create what you need.
Where you clarify that river corridor zoning isn't going to be municipal authority anymore, because AR is gonna take over that program. But yesterday there was a question that came up, isn't GovOps doing this? And apparently I haven't been able to confirm this. GovOps is something about building codes in the river corridor area. And I need to figure out how that would be implemented. And whether or not these conforming changes affect the ability of what's being done in the GovOps bill, so.
You're putting a flag on it.
I am putting a flag on this, I don't know how this will be reconciled.
Okay.
If it even needs to be reconciled, I just want you to know that.
That it's there.
Right.
I talked to the chair of GovOps last evening, early evening, and. Her intent at least was to steer clear of the work we're doing, make them complementary, not competing or stepping up to other stuff, so.
Well, I mean, there's definitely an opportunity for that, if the building code is going to be implemented at the state level by fire and safety. You don't have a problem. If the building code is gonna be implemented at the municipal level through municipal zoning. You might have a problem. So I need to figure that out, I don't know the answer.
Okay, well, I need to have a whole conversation then with the other here, a statewide building code implemented. It's a very rational idea that I have not seen much interest in on the part of. Because of capacity, on fire safety's part, so that came up in that work group all summer long.
So on page 19, line 14, section 11, this is kind of goals of municipal zoning, and instead of it say they shall meet or exceed statewide minimum flood standards, it's directory, they should meet or exceed the statewide minimum flood hazard area standards. So that is still okay with the change you made to shall. On page 20, line 6, and what a municipality can plan for in their flood resilience plan. I think it's okay to leave river corridors there on page 20, line 6, because that's where they're designating areas to be protected. I think it's okay for them to designate a river corridor for protection within their municipality.
Makes sense.
And then, but on
So
page,
you're saying even if they're not permitting
Right.
and regulating
Right.
it, they should still be cognizant of it.
right, why shouldn't they be like, hey, we should protect our river corridor because it provides flood resilience or flood
Yep.
management, etc. Page 20, line 12,
So,
the strategies that they. Since you changed may to shall, I think you want to change may to shall
Yeah,
here
here.
as well. Okay. Page 20, line 20 in the basic overarching authority for zoning shorelands, flood or hazard areas. You're striking river corridor protection because A&R is going to be doing that. Page 21, line 7 through 9, you're making the same change, but it's clarifying. It used to say flood areas or other hazard areas. Now it's flood hazard areas or other hazard areas. So that's the term that's used for that statewide minimums that's in the flood hazard area.
Okay,
Same change on page 21, line 17. And then the language at the bottom of page 21 on to page 22 is striking authority to zone for river corridor protection. Same change, page 22, line 9. They're going to be zoning for flood hazard or other hazard areas. And I think you're gonna have to change that shall to may.
year, and where have we gone now? Are you
Oh, 22, line 10.
Not much, yeah. So, and the reason that we're striking this, just want to double check, this is because by this point, we're now under the new rule.
Right.
And we're, unless that rule has figured out something about delegation,
I do think on page 23, you're gonna need a conforming change. It's all land development in a flood hazard area that is exempt from municipal regulation, but that is subject to municipal regulation, it's subject.
okay?
Because they still can't regulate state buildings, farming, forestry, and so forth.
Sorry, I was making a mark, what line were you making that?
I think it probably, I'm gonna have to figure out where exactly, but it's between, on page 23, line 7 through 9, I'm gonna take.
Okay,
The rest of the changes in that section are either clarifying it's a flood hazard area or striking reference to river corridor authority. And so that brings me to page 25. Line 4, section 14, this is the study committee from state administration of NFIP. The first change is that I don't think you need recommendations for a state minimum flood hazard area standard anymore because they're already adopting it.
yes,
So that would be out. Similar change on page 26, the bottom of the page 19 to 20, you don't need to assess the feasibility of creating state flood hazard area minimum standard environment. Page 27 is just a plea for me and the assistance to the study committee. You wanted it to be legislative council. There's only 2 legislators on the committee. We're trying to get away from staffing committees when it's a minority of legislators. But I'll just move on from there.
okay.
Wait, so you're,
Who staff? The agency.
so are you highlighting this because this is what should be changed, or this is? what-
Highlighting it,
So you're recommending-
we've been directed to note these. Where we're only staffing a committee that's a minority of legislators, raises issues for us in providing legal advice, so. There have been a couple of occasions recently where the non-legislative members have differed from the legislative members and wanted to do minority reports or wanted their own legal assistance. Separate from what the committee was doing as a whole, and that creates problems for us. Because our legal authority extends to the General Assembly, its members and its committees. Not to the individual members of its study committees.
Right, when that came up in the RAF group, which was 4 legislators and 16, I think, non-legislators, and those were, yeah, okay.
So your recommendation would be to instead have it be A&R, shall have the assistance of the Agency of Natural Resources.
I would assume that it would be A&R here. But you could probably find out out.
Well, alternatively, you could make it a study committee that was the majority of legislators.
Yes, you could do that.
Okay, so, Ms. Smith, can we flag this as a question maybe for your shop to consider whether or not you would.
If this is assigned to us, we will do it.
Right, thank you, we're gonna leave a flag on it and we'll finalize. Before we're done.
Okay, that brings you to page 29, section 15. First, the agency shall initiate rulemaking for the river corridor development rules no later than January 1, 2026. And the effective date of the rules shall be July 1, 2027. And remember, permitting begins January 1, 2023. Page 29, they are going to have those flood hazard area and river corridor rule for before they adopt the state minimum standards. They're going to continue to implement the flood hazard area and river corridor rule for development exempt municipal regulation, the flood hazard area and relevant river corridor. They already do this, so they're going to continue to do it. Even in those municipalities that have adopted it for river corridors.
So what, for municipalities that are regulating river corridors currently, once 2028 comes around, is that authority rescinding and now they are folded into the state program?
But that's part of the whole delegation question.
Yeah, oh, and the rulemaking will address that,
Right.
thank you.
Page 29, this is just the vested rights provisions. You're changing the permitting. Initial permitting requirements to January 1, 2028, and so I had to change that from July 1, 2028. And then page 30, it's 2 new positions at A&R to adopt the state flood hazard area standards and to assist municipalities in their adoption. That's 250,000.
Versus 300,000, which is,
Well, that's right. Should it be 300,000? Let's.
I think that's what we went to, 150
because you were saying it's 150 is what you.
That was the projection that I got from our business office.
Wasn't there some discussion of whether or not have more people, more persons?
I may have missed this, but I thought that there were 2 FTEs assigned for development of river corridor rules, and this is 2 assigned for development of flood hazard area rules. I'm not sure.
Yeah,
This is not the total.
Right, I think it was 4 FTEs total.
I believe that's correct. All right, do we move on?
Right. Thanks for, that was kind of the same question I had. So we had 2 in, we add people for,
I think I'm gonna have to just create a list of all the positions and all the appropriations.
okay,
Yes,
because we also were talking about supporting mapping, although there's already mapping underway, and
Could we request a fiscal? Still,
I have.
you had, okay.
Yeah.
So that would be,
Fiscal, but things are changing.
Right, so they have, I think they started on an earlier draft. I think on 3.1 when we first got 3.1, and then they know it's moving out again. So I will. They'll probably draft it out and then adjust those things near the end. One of the input flows. Okay,
So moving from the recorders, flood hazard areas, etc., into dam safety, the first page 37.
okay,
and Ms. Smith, you had, you, I had talked with you and Mr. Green about, kind of getting writing the way the agency would best like to see it expressed, so, I'm trying to think of how we share that, most easily in the way that we can all understand it here.
Or
So the program had some largely technical proposed edits to this dam safety section. I did not send them yesterday because I knew you were working on a draft, and I apologize if that creates more confusion, but I don't, whatever's easiest, I have them all in red line version, which I can send, but I can also talk through them now, if that.
So how about we walk through what we have? And then where there's something that the agency has a different suggestion on, we'll flag it, and then we'll get the red line from you.
Okay.
And then I'm gonna ask the committee if it's okay if I go on another lap with Mr. O'Grady to do some integration later today. And we'll see it's in the bill highlighted.
As long as it doesn't change the values that we've put in the bill, as long as they're technical and not a policy change, I would be very supportive of that. My only concern is that sometimes we hear that there are technical changes and then we find out that, oh, in fact, they are not as technical as I would have considered.
Yeah.
So that's the only thing. I think changing any kind of staffing recommendations, I would consider that not technical.
So let's back to Mr. Grady, we'll walk through. So if we hit something where you got language, let's follow.
Anything between page 30 and page 37?
Yes. The, your page numbers.
Which section?
Page 32, the definitions, lines 14 and 15. The definition of harm was originally added. It was underlined, it's not in the draft. It was added because the liability section as previously drafted referred to harm. Liability section that's in this bill does not refer to harm and it's not otherwise used. And the agency would advocate for striking that.
Yeah, I guess we don't use it anywhere.
Okay.
The agency, this calls a policy question up, but the definition of dam removal is also new and currently refers specifically to river restoration and resilience projects that remove all or a part of the dam. This is a limited definition and does not cover the full scope of what would constitute a sort of plain language dam removal, which may or may not be for the explicit purpose of river restoration.
So you're saying that and condition that it's restoration and resilience. It may, you still want to have a dam removal project, but it's not a resilience project or it's not a restoration.
This definition was added, yes, this definition was added because again, it's used in the revolving loan fund language. And the agency would advocate for a definition of dam removal that's sort of a plain language definition that doesn't limit the scope of what constitutes a removal project
So it could be dam removal means
for any purpose.
removes all or part of a dam.
Yep,
So the same change needs to be made in section 2 of the bill. Which relates to definitions in the wetland section.
I think that one just pointed to this. I don't think it's spelled.
Probably right. Mr. Carpenter, any concerns about
Yeah.
making it a more plain language definition?
For the record, Jared Carpenter, Lake Champlain Committee. Mr. Chair, I think that's fine. Obviously, people would love to see the language first, but it also references back into 75 County Section 2. I'm wondering if it changes the language in the wetlands section. Now, of course, I am not able to find it right now.
Section 2, top page 2, line 2 says the same meaning as section 1090 of this title.
Okay, so they'd have to change it both places, but I don't think that's gonna change the other language that refers to dam removal in the wetland section, which is what I'm looking for.
There's a provision in the wetlands section that exempts dam removal projects from wetland permitting.
Correct.
I think what Jared is referring to is limiting those projects that are exempt dam removal projects for the purpose of further restoration.
Correct. We can, the advocates in the agency can talk about this, Mr. Chair.
right. So for the dams, so there could be, we would want to reconcile the definitions, but for its use within the dams section of the bill, not the wetland section. Are you fine with the plain language definition?
Sound fine, Mr. Chairman.
Okay, so dam removal means. Removal of all or part of a dam
For any purpose.
for any purpose, okay? Thank you, Mr. Green. And thank you, Mr. President. It's Smith onward, and you can chase down the wetland version in case we need something different back there.
Yes, sir.
On page 33, line 2. This is a question for survey. It's struck through about the second to last sentence, starting with non-federal dams at which the generation of electric would be subject to licensing shall not be under the jurisdiction of the PUC. I think that language should be in there to clarify that it also won't be under the jurisdiction of the department, it should
Okay.
take jurisdiction. I don't know what a non-federal dam with a FERC license is. It's the language is odd, but we don't want those.
That's what you're getting from the city. Wait. Non-federal dams which are generally subject to licensing.
I think it's a misnomer from previous iterations of the language, because we define any dam with FERC license as a federal dam. So I'm not sure what this language means. We just want it clear that the department is not taking dam safety jurisdiction over anything with a FERC license. So if that language needs to be in here still, we would advocate for that.
And I don't know if it's necessary, but I can't say that for sure, so. Maybe just change PUC to environmental conservation,
Yeah, that was our tweak.
mark it out a little bit more than that, but it's fine.
Okay. And you're, just to make sure we're all following, this is in the sections 7 to line 7 to 14 on 33.
Page 33, line 15, there was a paragraph about transfer of records, which is struck through, which is appropriate if we're talking about a jurisdictional transfer, but A&R has some language that would require timely transfer of PUC dam records to the department when jurisdiction is transferred. It's a few sentences, so I don't know if you want me to read it aloud or just send it to my.
Read it, and then if you'll send the whole thing to
Yeah.
Mr. O'Grady.
Yep, so we drafted it upon transfer of jurisdiction of any dam from the Public Utility Commission to the department. The Public Utility Commission shall transfer copies of all records pertaining to the subject dam, including record drawings, construction drawings, engineering investigations and analyses, photographs, inspection reports, design and permitting and emergency action planning documents. To the department in digital and hard copy format acceptable to the department within 30 days of the jurisdictional transfer.
Please. Yeah. Makes sense?
Person on trade secrets.
Well, we won't share them publicly. They're just getting records. I believe. And
Anything else?
Page 37. 1086. Line 6, there was the discussion of how to direct the department to give consideration to public safety. And so there was a recommendation by Senator Lawson to move it out of the list. From subdivision 13, A13, and move it into the lead-in to the list. And so determining whether the public good is served, the department shall give due consideration for public safety and, among other things, the effect the proposed project will have on the following things.
The agency's fine with that.
Okay,
Moving on.
first among equals.
Yes, well, George Orwell.
Page 39. Section 1087. This was my attempt to address Ben Green's comments yesterday about the sections 1087 and 1089. Remember yesterday it said that the department shall employ an engineer or hire one that will be under the agency or the department's supervision. Mr. Green says the ability to require the dam owner to hire the engineer. So the department shall employ an engineer, hire a consultant engineer, or require the dam owner to hire an engineer to investigate the property. And then on page 39, line 16, it removes previous language referring to the engineer under the jurisdiction or under the supervision of the department.
And that was because we don't use that terminology anymore.
I think it was
With
because
the
Mr. Green didn't like the language that was in the previous draft, which came from a bill in the House. And wanted flexibility to hire consultants, still require the dam owner to hire them.
Yes, I just mean that very first line in 19, to change. the
That
department.
with the approval of the governor, that is just antiquated.
Yeah, okay, that's fine. There's not a change for.
The agency, I think that this achieves Ben's concern, this addresses Ben's concerns. I had put together very similar language. The only difference in the agency's proposal right now is under 1089. It seems largely repetitive of 1087.
Yes.
And so we had proposed to strike through 1089 and then just replace it with the department shall employ engineers to perform the duties required under the statute to adequately provide for public safety.
Yeah, I mean, that's fine.
It achieves the same thing.
Yeah.
Okay.
I think the concern from the program was largely that they be perpetually authorized to staff their program with engineers with technical expertise.
And does that eliminate 1087?
No, the language in 1087 is, that's fine.
1089, I think is what.
1089 would change.
Oh, okay, I thought you said that the language,
Straight through 1089 as it exists now, and then add that language to that I just referenced.
okay,
Which if you could, you're gonna send all that, right?
okay. Thank you.
And then you get to liability for dam.
We had a tweak in 1090.
Okay.
According to Ben, the industry standard is no longer for engineers to certify to certain compliance. He provided language that states the engineer shall provide confirmation to the department that the project has been completed in general accordance with the approved plans, specifications, and dam border conditions.
So a more explicit list of what's getting reviewed.
That and again, it's in the model dam safety program manual is urging against certifying to things and rather providing controls. It's essentially semantics, but this is consistent with
Right?
what the consulting engineers are providing.
That work from your standpoint?
Yeah, I just
Application.
need the language, I think that's fine.
Okay,
And then you get to the liability section.
this is where we paused yesterday.
And so I just. This is effectively the Massachusetts language. It does require the person owning legal title to the dam to be responsible and liable for damage to property of others or injury to person, including loss of life resulting from the operation, failure, or misoperation. And then it goes on to say compliance with the chapter or rules adopted under the chapter does not relieve or lessen that responsibility. So it's not about their negligence or their compliance with state law, they are liable. In addition, it doesn't matter if DEC it did an inspection and reviewed a technical document or issued a permit for the dam. The owner is still liable for the failure of the dam.
And if our agency is neutral on the liability question. Okay. So for the committee, I wrote 2 days ago to Mr. Green's counterpart, and he was kind enough to supply me with a contact down there. I haven't heard anything back from the first, I don't know, the simple thought was, if this is a Massachusetts standard and they have dams, I'm assuming, but not assuming without verification, that they're all insured. And so how's that possible? So I'd like to leave the liability question pending, set for the time being, and but I wouldn't want to move it in the bill if we didn't know that we had the insurance question sorted out. At least to our satisfaction. It would be easy, there'd be more to learn after we move the bill, we can always adjust things after, but it'd be as part of a solid straight face test before moving it to just get that kind of confirmation out of Massachusetts. Mr. Zucchi.
Yes, Dylan Zwicky with Living Line on behalf of GMP. I think we largely agree with Mr. O'Grady that A does try to implement this language. However, the language in B is somewhat different and seems to focus on defects and not failures. A dam could fail for any number of reasons. For example, an earthquake that would really have nothing to do with anything within the dam operator's control. And so I feel like this don't endorse Massachusetts standard, but if you are thinking of aligning with that, you can align so B with Massachusetts as well.
So you're saying Massachusetts has additional language that addresses things beyond their control, like earthquake? I'm sorry, I'm just trying to make sure I'm following.
So yes, Massachusetts language is, and references Mass statute, shall not relieve or lessen the responsibility of any persons owning or operating a dam from any damages to persons or property caused by defects, nor shall the commissioner be held liable for any reason for any inspections that involve documents or permits. The language in B in 213 is shall not lessen the responsibility of the owner, person owning the legal title to the dam for any damages, persons or property caused by failure of the dam. So it's defects and failure, I think, is a substantive difference.
Mr. O'Grady.
I'm fine with that. I think defects is actually a broader scope of liability than failure. But it's fine with me.
And just to clarify, we are not supportive of this language, but I think if we're gonna move in that direction. If you're saying you're mirroring Massachusetts, it would be, if you advise, so I should follow.
So do you have that edit and I want to write it down and not ask for a change yet, in part because of what you just said. It
Yeah.
broadens the liability,
Yeah,
we're trying to make this the manageable first liability, broadening it seems like it makes it even a harder threshold to get
It's
over.
required kids now.
And
So you're.
you may also want to hear from the Department of Financial Regulation in Vermont, since they would have very good understanding of insurance markets and what
Yes.
products may or may not be available, they may not be the same products that are available in Massachusetts.
Mr. Chair.
Seems like,
Thank you, Chair Bray. I'm not sure if you were soliciting comment on your plan to move forward with keeping this language in, or
Sure.
that was a general statement of the plan.
well, that's, the plan's always open to change.
Okay,
I was just trying to, in general, I try to keep the ship moving, so if there's something that's hanging on us. I wanna have a plan for how we're gonna deal with it. in the country, but so what do you think?
Well, it seems like you are moving forward with the plan, so I'm endorsing your plan. I think that's fine. I also would like to hear from DFR.
Yep.
That would be very important to me. And this is still a section of the bill that while I feel that folks should have as strict as we can, the strictest kind of liability for dams, I am very concerned with the implications of having to self-insure some of our dams or not have insurance for them. So I appreciate that your plan is keep it in, take it out if we must, if I'm understanding correctly. I'm just wondering when you hope to vote on this bill, we may not have an answer.
Right, so,
And I personally would prefer if we do not have an answer to not change it. So I look at it the other way that you're looking at.
leave it in for future confirmation.
You wanna leave it in for future confirmation.
No, I.
Oh, you want it to-
If we
okay.
can't confirm before we vote, I would say. Take it out,
Okay.
we can hand.
Then we are in agreement.
When they
Okay,
go to the House, we'll have time, and the House will have time, we can revisit the liability question and then add it back in. I
okay,
mean, the value of life, sharpening up the liability language to me seems like. Liability is what makes people pay attention.
yes.
And if there's any vagueness around being viable or not, that invites people. Not to pay attention to the implications out there. And especially that may be, I think Mr. Carver said, private dams, the utilities are keenly aware of. The safety question and their liability.
Okay, so we're in agreement. I thought you were saying keep it in unless we hear otherwise, but you're saying keep it out unless we hear otherwise.
Yeah, so just leave it for a few more days, right where it is, in case the answer is yes.
But we're voting,
Friday.
Okay.
With 2 days.
Okay.
So
the whiteboard is incorrect.
that's okay. Are we clear?
Yes, I now understand your plan.
I don't wanna say, please take it out, and then tomorrow we get testimony that says, oh, this actually works, and then say, please put it back in. We're just leaving it until we know that it should be removed.
Okay. I think
I
we
think you
are,
draft
I
or
think
not
we are
wait
in
things
agreement.
out.
I think we are in agreement. Okay.
Should I move on?
Yes, please.
On page 41 in section 1095. This is the unsafe dam petition language. Previously, there have been language striking the discretion of the Department of Fixed Economic Affairs for a hearing and shall give notice in the matter to all interested persons. That was reinstated. Seeing similar change on the bottom of page 41 about the department made petition the Superior Court in the county which the dam is located in the first quarter. That struck language is now reinstated as state agency having jurisdiction which came to the department. Has he changed that?
I'm sorry, what was that?
At the end of 1095 sub B. Do you have any changes in that?
No.
Okay. All right, that takes you for changes. To page 43. Do you have any changes between them?
Nope.
Okay. Page 43, line 18, this was just changing state agency having jurisdiction to department. And then on page 46.
Okay.
This is language for in the dam safety revolving loan funds. And what non-emergency funds can be used for. It's grayed out on page 46, lines 6 through 10, because I think there's negotiation, I should say, going in between advocates and the agency about what this language should be used for.
The state's only provision here is. This would be it looks like it's on page 46 now. Page 46, line 6, you've flagged it as gray because there are. unresolved issues, the agency would propose that for eligibility for non-emergency funding, an alternatives analysis is conducted that considers an evaluation of risk reduction, dam safety, and environmental permitting considerations. Striking through the language, it says floodplain and wetland restoration, water quality, aquatic organism passage, and public recreation opportunities. The program's objective is that this alternatives analysis should focus on the most cost-effective solution for reducing risk. I know that there is policy disagreement there.
And Mr. Carpenter, how would you frame up
Yeah,
why you would prefer wetland restoration, water quality, aquatic organism passage, et cetera?
so Jared Carpenter, Lake Champlain Committee, in differentiating between the two, we understand that there should be certainly a lot of flexibility to the dam safety program for the use of emergency funding, when to use emergency funding, obviously it's an emergency. But when you get into repairs and non-emergency funding, we wanted a broad risk analysis, an alternatives analysis to look at all the other factors that are involved, not only in repairing the dam, but what would happen if you remove the dam. And so that's where you're getting into your wetlands restoration, your water quality, your aquatic organisms, et cetera, et cetera, et cetera. That should really be the drive, for a non-emergency repair, if it's a loan or a subsidized loan coming from the agency or the taxpayers. We think the drive should be towards removal of these dams. That is the safest thing to do, rather than repair the dam in a non-emergency situation and then have the owner have to come back and offer a maintenance plan, and what happens in 10 years when something else starts to fail, are you coming back and fixing the dam again with more money from the state? Emergency is completely understood, it's an emergency. Non-emergency seems to us to have more options should be considered before loaning money for repair. And that is where in these two, E and also in F, where we would prefer to drive this towards removal and not repair.
And by having a longer list of things considered, like wetland restoration, opportunities for wetland restoration, water quality, aquatic organism passage, public recreation opportunity, how is that going to show up in the analysis? Is someone going to quantify the value of those things, and someone's going to say, the removal version is preferable because the benefits, the quantified dollar value of the benefits exceeds the cost of repair? I'm just trying to think of what that analysis tells you.
Regretfully, I'm not the best person to answer that question, but I'm not sure if we could quantify things like, in terms of dollar signs, if you wanted to weigh the repair is going to cost $100,000 and the habitat restoration is a dollar signs equivalent. There is further down in the bill, there is rulemaking requirements for criteria to be considered that the department would set, but then an independent party would look into. I know one thing that Ben didn't want to do was have to do the alternatives analysis himself, which is completely understandable. So, but an alternatives analysis will be required by an independent company, engineering group, what have you. And my understanding is when they do consider removals and the costs, and they have to go through all the different stages of the engineering, that is all weighed in, but I'm certainly not regretfully an expert in the animal.
And the analysis is going to be delivered to whom for review? To go to Mr. Green's shop?
I will try to channel Ben here, but the alternatives analysis, when there's a dam that requires repair, or action in order to address risk. An engineering consultant is hired who does the analysis of what the issues are, and in the process prepares an alternatives analysis that looks at potential solutions to reduce risk. So that's part of any engineering analysis that's done for dam repair. That would be present, and then from there, a project proposal is developed. In these situations, that project proposal would be given to the agency for review to ensure that it conformed with our rules and requirements. But it would be developed by an engineering consultant hired by the dam owner. The agency's objective in focusing this language on an evaluation of risk reduction, dam safety and environmental permitting considerations is largely to streamline what an engineering analysis would do under normal circumstances when it's conducting a dam review.
Right, so you're adhering to the law. If there's a legal mandate to look at permitting conditions, you would look at those. If there's a safety thing, you're looking at those. But if it's beyond that, you don't expect an analysis to be addressing those other points,
I think that
like recreation opportunity.
correct, what largely this language reflects what the industry standard is for dam engineering analyses. So rather, I wouldn't say the law necessarily, because this revolving loan fund language is really talking about disbursement of funds for these projects. But for those, we're sort of like, this is the practical reality of what an engineer is looking at when they're conducting a review of a dam that requires repair.
So
Certainly.
thank you, Mr. Chair. So I'm trying to follow along because it seems like you're both saying kind of parallel track things that the language is doing. So it doesn't seem like you're disagreeing with each other, but that the purpose of the language is kind of hitting two different goals, if I'm understanding correctly. So you like the way the language, I apologize, the agency prefers the language that is here now.
We would modify it.
You would modify, and you prefer the language that is here now. The advocates prefer the language that is here now.
Correct.
I guess I don't understand what your change would be.
The fundamental change is actually starting line 12 in section F.
Okay.
So it is a little bit in the weeds regarding what is reviewed during the alternatives analysis, but the program's objective with those revisions to E would be that the focus be on risk reduction when conducting an alternatives analysis. The more fundamental policy disagreement I think we have would be beginning on line 12, where it's talking about what's eligible for loan subsidy, which is essentially loan forgiveness. The agency, it reads now, under this subsection, only engineering analysis, design and construction that results in removal of a dam are eligible for loan subsidy. The agency would propose that says engineering analysis, design and construction that result in acceptable risk reduction are eligible for subsidy. The agency is proposing that any project that provides acceptable risk reduction be eligible for subsidy. The advocates are proposing that only removal projects be eligible for subsidy.
And, okay, I guess I'm kind of undecided on this one. Because it seems like, yes, I agree with what we've heard, that we don't want to just kind of create another situation where then 5-10 years down the line, we're just continuing to repair them. And this is non-emergency.
Right.
So this is an instance, but I also know that there are dams in our district where they would not be repairing them without support. So it makes me nervous to not have that be available to them. However, this is a limited pool of funding. This is a tough one. I actually don't know how I feel yet, and I would want to.
Yeah.
I would like to keep it as is.
Do you want to see the alternatives? Well,
Yeah, let's,
we'll just put the alternatives in.
Okay, well, that sounds like a good, no, I mean, it is the use of public funds for repairing of something that could be. I mean, a private dam, a lot of times in the consideration, we're talking about insurance and other things, we're talking about. GMP and on big hydro dams, we're not necessarily just talking about somebody's little dam that can still do. Damage, and whether or not public funds should be used to repair a private structure that somebody derives their own benefits from, it's not necessarily a public benefit. Therefore, why should we be using public funds? And then subsidizing the loan for free, basically, in a pool of $1 million that's being used for emergencies.
I think that's where, yeah, I get a little.
Well, the state does that a lot for water and wastewater when it goes to municipalities. Not for.
But that would be, we owe some $100 million right now, that's all right, somewhere.
Right, how much money is in dam safety?
Right now, about 350,000.
But we're putting in 1 million.
It's in the budget, yeah, the budget's proposed.
Currently, that fund is only available for dams that have been deemed unsafe pursuant to the process in 1095. This proposal would expand eligibility for funding. Which the agency fully supports. It's very logical. very hard to us.
So, I understand the issue well enough, I'm leaving it flagged. I would propose we leave the language as is, still in gray, because we all know it's not settled yet. And let's keep going, because we're making pretty good progress on the balance of the bill. Senator McDonald.
Well, we're gonna move on from deals with all dams in the state, or?
That would be my understanding, all
Well, we
100 plus of them.
Yeah, we have a couple hundred, plus or minus mill pond dams around the state. There was some drafting in a legal ad for 1-800 number involved to find out how you could give your dam to someone else before it fails. And how do we, anybody that owns such a dam now, they could get rid of it, would probably be a lot better off than they are before they get rid of it. And I don't know how does this document recognize that situation?
That a dam owner is better off without the dam?
Yeah.
I guess that would depend on the dam.
So people sell liability all the time. And it is up to the parties to that regarding how liability is sold. And the division of damages that may occur based on liability. It happens all the time.
Yeah, but little dams like what's it there's a dam on the way out to the Maple. Pretty neat place on Route.
Oh,
There.
yeah, there's a couple little ones here and there. There's the Bailey's is one near Shaw's, there's the Pioneer Street Dam, which is near Pioneer Street. Further up, and then, yeah, I mean, there's series of.
Brookfield's dam with the floating bridge was rebuilt by the Agency of Transportation to float the bridge. But when it failed and the bridge fell down several feet, still floating. And where the beaches used to be, there was sometimes 15 or 20 feet of mud flats. And there were other houses that were just stranded. But there are a couple hundred dams like that. Anybody that owns one is crazy.
Yeah.
Sounds like a policy question.
So we only have council till 11, both councils, so I would suggest let's pause this piece. It's a bigger conversation, and I'd like to see if we can get to the end,
alternative.
because that'll help us have as mature an extract as possible, leaving this question and the insurance question aside.
I don't have any further changes until page 15.
That's where our exchanges come.
Don't do everyone. Well,
And that, for me, is in the dam registration reports. Page 50, line 17, I don't know if there's anything before that.
We do have a proposed change above, beginning line 7. This is where new language regarding the agency's rulemaking begins. It requires that we adopt rules that outline requirements for access to financing and subsidy from the Dam Safety Revolving Loan Fund. Beginning on line 9, there's additional language that says the rules should also lay out requirements and criteria for an alternative analysis, including that it be conducted by an independent third party and is necessary for eligibility for non-emergency funding. The agency is proposing to strike subparagraph 7 that begins on line 9 through 11 and add on to subparagraph 6 so that it reads requirements for access to financing and subsidy from the Dam Safety Revolving Loan Fund, including the requirement that an alternatives analysis be performed by an engineering consultant hired by either the dam owner or the department. The reason for this change is that The term independent third party is, from an engineering perspective is confusing because typically the alternatives analysis would be performed by the engineer hired by the dam owner during their review of the project. I don't know if there was a specific purpose for this requirement around an independent third party, but from the program's perspective, that would require an additional person to be brought in for what's typically part of the review process.
Is this, Mr. Governor, anti-cherry picking your engineer provisions?
No, I think, yes, I think it's, I think the use of independent third party was just a way of saying. Somebody who's not in the program, you know, a third party, I don't think there's any intention of. Hiring a fourth party,
Okay,
but necessarily,
yeah, and that's consistent with the agency's understanding. The agency would not be performing this review.
correct.
Rather, the engineer hired by the dam owner would do it.
So this was, yes, we drafted this specifically on Ben's concerns that. The program would be expected to do the alternatives analysis, when instead the owner could hire a independent third party outside of the department to perform the analysis.
Okay, so is the
That sounds fine.
agency's proposed language work for you?
Yes, it sounds, of course, the caveat, I'd love to read it first, but yeah, it sounds.
So we'll see it in place highlighted next draft, okay, thank you.
Okay, so I think I can move on to section 17. So that is a change to the deadline for the department's report on dam registration. 2019, you require dams to start to be registered. Prior report on registration. The agency is asking to push that date back to 2026.
This is.
Living registration.
Yeah,
Yeah, okay,
so the change is on page 51. Actually, page 50.
okay. And that fits with a timing request from these, okay? Any concerns about like that?
And then on page 51, going on to page 52, this is a change to the deadline for the department to adopt dam design standards by rule. It's being proposed to change from 2024 to 2025.
So this is the phase 2 rule, correct?
Yes.
So I'm missing,
It's 52.
oh, 52. Okay. Thank you.
Yeah, I was looking as well. And then I get to cheat because I get to see where he is.
And it's good, and just so I understand, why is all the language in those two sections highlighted? Is it?
These are new sections.
Yeah, right, it's not that there, not changes since our last conversation, got it. Okay, are we all good to go? 19.
19 is the money for the dam safety division. If you're gonna go with 150
Yeah.
per position, you have to increase that.
To 450,
Yep.
right, I need to,
And
then for people tracking, so that is. Taking the two limited service positions and turning them into permanent, and then adding an additional new person on top of that.
Yes, I will note that the program has identified significant capacity needs. I'm not authorized to say or to ask for 11 FTEs right now, but I think if you talk to Ben, he has identified areas where they lack capacity, particularly if we're taking on the portfolio of dams that currently are regulated by the PUC.
Yep, and I think when he was in December 5th, he said the same thing.
Yes, I think he provided a breakdown of some of his.
Yeah.
Yeah, so
Okay, great.
it's just a note from the agency.
okay, moving on. Section 20 is that study from other bill, separate bill, to review and recommend how to improve regional emergency planning for hazards caused by dam failure. including how to shift responsibility for emergency planning and funding from municipalities to the regional authorities.
Sorry, Mr. Han, Mr. Twiggy.
Yes, thank you, Dylan, for the record, just we would make the suggestion that among the membership. It may be worth adding a second dam owner and specify that the second dam owner could be an operator of a hydroelectric facility.
Ms. Smith?
The agency would also recommend that, the agency has two recommendations related to this section. Substantively, we think that the committee is a good idea. It's titled Committee on Dam Emergency Action Planning. An emergency action plan is a document drafted by a dam owner that outlines what the inundation area is below the dam and what actions the dam owner would take. I think what the intention is for this to be a committee on dam emergency operations planning. Emergency operations planning is actually executed by municipal emergency managers. And I think the intention is that the committee is exploring how to use regional resources to better coordinate emergency response. Relatedly, we would suggest that some municipal emergency action plan could be included in the members of the committee.
Say that one more time, a municipal what?
They're either emergency operations planners, or let's see, emergency operations. Sorry.
We had a long discussion in Senate government operations about the difference between emergency management personnel and emergency managers.
Yeah, and I have notes and now. Emergency management directors or incident commanders. That was the language proposed.
Yeah, great, because I think, we wanted to make sure that we started with, do you have an emergency, whatever, emergency action plan? And now have we communicated it well to someone who can use? Okay, so they seem like two positive ads, hydroelectric, including making a second category of someone operating an hydroelectric facility, and then the emergency operations.
Yeah, I think depending on the municipality, they have different titles, but it was, sorry,
You have both of the terms in your markup.
yes.
She both from that side were similar position.
Great, okay. And then the section title changes a little.
Yeah, and the reference to the committee's name, the route, which can as well.
Okay,
Who changes?
thank you.
And you don't feel it's enough to have someone who is appointed by the governor from the Division of Emergency Management?
The folks, the municipal staff who are on the ground are going to be really relevant in helping to understand how these plans are carried out.
Okay, the next substantive section is section 21 on page 56. This is the provision where,
So I'm just noting, we grade out the assistance thing, if we're having a primarily non-competitive legislators. Committee, we will consider housing it outside flood council. Got it?
yeah. Page 56, line 5, section 21. You know that PUC is transferring the 21 dams, electric generation dams that they regulate to DEC for the purpose of regulating public safety. There is an opportunity for either PUC or DEC to petition FERC to take jurisdiction of those dams so that they would no longer be in the jurisdiction of the state. It would be regulated by FERC. This recognizes that first sentence, page 56(7) non-federal hydro dam without a pre-1920 license may be subject to FERC regulation and may require a FERC license to operate by December 31st, 2024. PUC in coordination with DEC shall file petitions for declaratory order from FERC to determine whether projects currently under the PUC's jurisdiction fall under FERC's hydroelectric licensing jurisdiction. PUC shall provide notice to the dam owner when a petition is filed with FERC. I think DEC has one more sentence that they would add to that language. And I did not include it because why don't you say what that sentence is?
The sentence is, it's not gonna be verbatim, but PUC shall retain jurisdiction over those hydro dams until a FERC determination has been made.
So there's no gap.
Well, there wouldn't be a gap. What could potentially happen is on a date certain jurisdictions transfer to DEC and then 6 months, 1 year, 5 years later,
5 years.
FERC makes a determination. And then the dam is transferred again to FERC. The FERC process can take a long time, especially if dam owners appeal the determination. It has taken up to 8 years.
Well,
Right, so you're effectively leaving jurisdiction with those dams. With the PUC until a FERC decision on the petition. Which could be years.
Right.
But I didn't include that sentence because I think that's a policy. I don't want to assume that.
And what's the department's position? Is you'd rather not have it transferred while a petition is pending?
how many are pending?
Well, we haven't filed any petitions yet. That would be part of this requirement that by the end of 2024, we in coordination with the PUC, petition to FERC for a determination.
So let's say of the, what, like 20 dams-ish, you put in a petition for
This requires
15
petition
of
for
them,
all.
for all of them. You hear back and they're like, we will be considering all of them. None of them would actually transfer to DEC then.
Correct.
Yeah, I don't love that.
What's the concern on the receiving side that
Transfer of a dam that generates electricity these are complicated facilities. And again, just channeling Ben, the amount of resources that it takes for DEC to familiarize itself with the dam.
Yeah.
It's a substantial burden. And so for us to take jurisdiction for a short period of time and
the FERC
familiarize them,
accepts it?
right,
And why did you do all that?
correct.
When
And it
DEC
also,
was already managing.
and it creates, it's a level of uncertainty for the dam owner too, who is dealing with multiple regulatory agencies over some period of time,
Sure.
in theory, right?
Well, is it fair for me to characterize the dams that are in this list of 20 as probably some of the most scrutinized and regulated dams in the state?
Some of them certainly are.
Okay. Well, I'm just thinking from a risk point of view, if the status quo doesn't carry some sort of increased risk, then I can well imagine you wouldn't want to go through the entire exercise of taking over a dam only to have FERC accept it.
That is A&R's position. I will just say, based on conversations with PUC that happened when this language was being considered, the PUC would like the transfer to happen on a date certain. PUC and A&R do not agree on this point.
Okay. And Mr. Carpenter,
Chair Carpenter, yeah, we had set the timelines in the bill, and if I'm remembering, there's a lot of timelines of the high hazard dams being transferred by 2025, because of the specific reason that they are high hazard dams. And that's just potentially making a high hazard dam being transferred over by 2032 or something along those lines. So it's, and it doesn't change the fact between here and there that these are high hazard dams that should be the responsibility of the dam safety program. But we certainly understand why both agencies would like the other one to take responsibility of this between now and then, and we get the extra burden, but hopefully FERC can operate faster than 8 years. Maybe the high hazard dams can transfer, and maybe it's resolved before 2028, before the others have to be transferred.
what is the date for transfer? Moved out?
The agency would certainly support that.
Well, it would provide a longer window of opportunity for some of those determinations to have been made, so you don't get the fire bill.
That's
taking out a dam only to have it be moved, accepted for certain.
So those dates are on the top of page 57.
Okay. So I would ask the parties here, I don't know, so Mr. Zwicky, you have to have a connection to a number of dams. How many are in this category?
The total universe of PUC regulated dams is 21, and believe GP is in the order of 10 to 12.
And just off, okay. And just so we're informed by maybe one of the larger dam owners, do you have a position on this transfer? And the current, yeah, something stuff there. Is there a position on the part of your client on how they would like to see the oversight of their dams evolve?
You heard that they operate all their dams in line with FERC, whether they are currently regulated by FERC or PUC. I would have to double check on what their preference would be with respect to the requirement that either ANR or PUC first petition PUC before the transfer happens. We sympathize with ANR is concerned that they could take over oversight of a GP facility in 1 year, and then 18 months later, then have our rule that it is subject to further jurisdiction. I can't back over, presumably have some impact on the operation.
Well, and given that part of all the things we're doing here, the new staffing is to help address a backlog of work. Because there's so many other dams, these seem like they fall into the category of highest level of maintenance, least risky than trying to balance things out. Well, I would ask Mr. Carpenter and committee members to mull over whether or not moving these at the later date, which is 28. Like they would say the petitions would be filed, the current regulatory regime would stay in place, and then at 28 they would transfer. That way, if some have been taken over, they'll be off the list, and there'll be less of ANR taking out stuff, only come and do it. Is that?
the 2028 date for transfer is preferred by ANR.
So I would ask you to think about that proposal, or if you have a position now, then.
I can certainly turn back and talk to the other folks that I'm working with, but again, it's the high hazard dams at 2025 that should be transferred over more promptly. That was sort of our mindset and splitting the 25 and 28. And theoretically, lots of theoretically going on, they could get transferred in 28 and then be over there for 4 years, and then FERC could decide at the end of your time period. So it's
Sure.
there's no perfect outfit.
Yeah, I get it. I'm just thinking that if it's a hydroelectric facility, there's a tremendous amount of engineering built into the thing, and I'm imagining it's a complex portfolio to take over.
I would just say in response to Mr. Harper's point there, but high hazard dams moving over quickly. I mean, I think you could also argue that you've heard from ANR that staffing up, getting familiar with these dams to take a certain amount of responsibility. If the concern is high hazard dams, I'm not sure why you would want high hazard dams to be put in the jurisdiction of an agency that is maybe not ready to take on that responsibility. That would seem to have less focus on safety in my mind, but that could just be
That's a broader staffing push, yes.
Doris, maybe here's something that will be helpful before our next review, and we could make a decision then. Could someone here make a list of I think we actually have a list of the PUC dams, and what I don't see is a list of their condition and a list of their risk factor. So, if someone compose that list, that way we'll see what would transfer and what the risk, the condition of the dam, as well as the hazard level of the dam. Then we would be in a better place to see what we're leaving ourselves exposed to.
Okay.
So,
Thank you, Mr. Chair. I realize you're kind of soliciting feedback from the external forces.
Yeah.
Personally, I do not want to change the language. Even though I understand the concerns that are being brought, but I am unpersuaded at this point.
well, that's, yeah, and thanks for that, you know, I wasn't assuming that, oh, if we hear agreement from out, off the table, that that's our position.
Okay,
I just was trying to see, understand better other people's thinking on it.
and I'm 1 vote of 5, so.
Very important.
Sarah, when we're doing this in the first place. Example, yeah, that this is a more of a natural resources issue than it is an energy issue. Right,
I think it's also consistency to have one regulatory body. So the auditor's report had called this out as a problem because there are 2 different regulatory bodies. The issue is FERC is like a whole nother thing altogether. I don't necessarily agree with the point that was made that this would make them less safe because of low staffing in DEC. I think that what we've heard from their staff is even with the level of staffing now, that they are able to maintain a really high level of public safety, which is absolutely incredible. So I don't necessarily buy that argument. And I think for consistency, it would benefit us. And maybe the case can be made that it is more of a natural resource question than an energy question, but
At the end of the day, I believe there are 4 high hazard dams that will be transferred over by 2025, not 40. So I would assume 4 dams will be manageable for the current program.
yeah, or can just calling over,
yeah, they can,
It's easy for us to say, I'm just,
is that the right way?
like, what are the, you know, what's the complexity of what's getting handed over? So I would just like to flag it as, let's learn more. And be in a little better position tomorrow to come to a conclusion. I suppose there is also the other thing of picking an intermediate date between 25 and 28.
Yeah, but
That option remains out there too. Okay, let's keep
I'm
going.
not doing anything.
Nothing severe, nothing. You know, that was a lot of talk to.
yeah, you
A lot of conversation takes step.
So moving on, section 23. That's the basin planning, no changes there. Section 24 is foam. There are changes here on page 61. These are recommendations from CLF, I believe, after discussions with DEC. I'm not certain of that.
And Mr. Overstreet has just popped up on the screen behind you. Good morning. So my understanding, this is kind of between the agency and the CLF and other interested parties, this is a compromise or edited language that there's mutual agreement, mutual support for, or is that too strong?
I generally, yes, mutual support. We did just text Pete to let him know that your committee's moving on to this, so hopefully he'll join via Zoom.
Okay,
But we have discussed the length of the CLF. He plan? Yes.
Yeah.
He declined my invitation. Oh, earlier today. Did Bethany Surgeon accept it?
can you send?
Yeah, I can resend, I'm just saying.
Okay, so let's start going and hopefully you can let them know that.
Yeah, I let him know.
Even if you decline it, will be in.
we'll take it back, Vicky.
My system, if you decline, you can open your trash and make the page is still there. Okay, let's start.
So I don't know, do you want Mason to walk through these changes? You want me to walk through?
Mason's volunteering, so yeah, why don't you walk us through the proposals of change and explain maybe what the, not just the change, but the rationale for the change.
Perfect. Good morning, Chair Bray, members of the committee. For the record, Mason Overstreet, Conservation Law Foundation. I apologize for not being able to be there in person and appreciate the opportunity to speak about this. So really quickly, the changes that Mr. O'Grady has inserted into this latest draft, draft 4.1, everything except for, I'm on page 61, line 3, section 1322A, everything except for this section I can't see Mrs. Smith, but Ms. Smith, you know, I think it's fair to say that we are in agreement with the agency on this particular section. And again, Ms. Smith, correct me if I'm wrong, but the characterization and concern from the agency broadly about this particular issue, including this section, is one, enforcement and their lack of staffing to enforce. And two, staffing and resource needs. And so the concern about the language here, which is highlighted, which prohibits expanded polystyrene foam, which advocates feel very strongly that and would recommend this particular language to the committee. The concern of the agency is that distantly this, you know, let's say touches on enforcement or an enforcement responsibility. We disagree with that. We do not think, you know, the language has been struck throughout this polystyrene section. So there, in our view, there is no legal responsibility for the agency to enforce. So this, I guess, summarized, this is simply a straightforward prohibition on polystyrene, which we would recommend. But Ms. Smith, please chime in.
I agree with CLF's characterization. The agency is concerned. We read this as similar to the prohibition that went into effect on the individual polystyrene food containers. You know, the agency is not, we don't have the capacity to go door to door and like take your food containers. Similarly, we see this as a prospective ban. Moving forward, this product would be phased out. The bill proposes that it would no longer be allowed to be sold in the state. I think the concern is just we don't necessarily have the capacity to be looking under everyone's stock. If that's the expectation, they would be treating this generally as a ban moving forward.
Right, so, well, one of the other hangups, let me make sure it's because it's not so easy to see what's gone. There was going to be a removal provision, right? Like at a certain date, you had to take it out, wasn't about adding more to the problem, so that's gone.
Correct.
Yeah.
And now we're just saying it's prohibited in the sale of polystyrene that's not encapsulated begins what date?
There we go.
This goes into effect on the effective dates, on passage. No, actually, July 1, 2024, but the rulemaking text has on passage.
Okay, Mr. Overstreet.
Yes, I see that now Ms. Sargent has joined, and so I think she's probably best to respond, but I would add that I fully recognize, appreciate, and respect the agency's desire to focus on prospective new installations here. And I know the agency would prefer to put in the language new into 1322A. Again, we feel strongly against that, do not think it's necessary, and do not think there are any enforcement obligations or requirements or burdens on the agency. But Ms. Sargent, please feel free to chime in.
Thank you, Mr. Overstreet. Yes, sorry, I'm just able to join you now. So the agency feels strongly that, you know, the intent of this section of the bill is to phase out new installations. And so I think clarifying, you know, based on the ban of the sale and clarifying that, you know, the intent is to, you know, that these materials would no longer be used in the new installation and is important. And part of the desire to add new to the language is to clarify that this doesn't necessarily apply, given that docks are taken out in the fall and left out in the winter months and then put back in the water the next season, that, you know, that this language wouldn't necessarily apply in those examples.
Okay, so if agency had its preference, what word or words would you insert in the version that we're looking at?
I don't have it up. Let me get it.
Okay,
Up
and
here.
this is sort of where you're heading. We're on page 61,
Okay.
draft 4.1, and we're in section 1322.
All right, just bear with me here while I open it up or seek to track down the version that you're looking at right now. Is it posted on
Yes,
the committee's website?
yes. Yes.
Bethany, if I can, and if the committee would allow, I believe, Bethany, your edit would be pretty straightforward in that you would be proposing new in front of expanded polystyrene on line 3. But again, we would strongly push back the intent of this language and of this section in the bill is to prohibit, let's just call it bad stuff. It's a very straightforward, pretty simple issue. And so the intent is not just prospective. So
And polystyrene encapsulation required, expanded polystyrene from use for filter shall be encapsulated.
Yeah, Mr. Chair.
Yes.
I understand the debate that's going on here. I would prefer that we keep the language as is. Or take it them. Poll.
As I understand the agency's concern, it's around that if we don't have the word new, that you're feeling like anytime you encounter polystyrene, whether encapsulated or not, you're gonna have an obligation to act, to notify someone or observe or warn, whatever, the whole procedure that Mr. Laflamme referred to, which I understand, it sounds like multiple steps. You have to document, notify, get a response, follow up, etc. Is it that you're thinking every time you see it, you're gonna have an obligation to do something?
I think the addition of the word new just clarifies that that the intent is that this prohibits these materials when you're installing a new dock and not necessarily when you're putting your dock back in the water after a season of, after a winter season.
Okay. So I'm gonna look to our lawyer and say, when you read it without the language as it exists now, does it suggest an obligation on the part of A&R as you understand enforcement?
So this subchapter is included in chapter 47, title 10.
Yeah.
Which is one of the chapters that A&R has general enforcement authority over in 10 VSA chapter 201. And the applicability of that chapter starts with the secretary may take action under this chapter to enforce the following statutes and rules, etc. It is discretionary enforcement authority. They do not have a mandate to engage in enforcement. I understand their perspective that they want this to be on perspective new, but they are not mandated to enforce underneath their actual enforcement authorities.
Okay. I don't know if with that clarification, Ms. Sargent, that addresses the concern that you can apply discretion and therefore you're not bound to act in a manner that I could easily imagine would be of concern.
I understand Mr. O'Grady's point and agree that the agency has discretion and enforcement in this instance. I think the inclusion of the word new clarifies for those individuals that this would apply, that the intent is not that they can no longer put their dock back in but that it would apply to new installations, specifically.
Okay. Ms. Smith, anything you'd like to chip in on this conversation? Otherwise, I think we'll leave it as is, and the committee can mull this over and come back to it on the next read through. I would suggest we leave it and come back to it. Ms. Smith, anything you want us to think about from your, from the sergeant? I don't know.
No, I think that, Bethany's clearly articulated
Yeah.
the concerns that the agency has around this. And outreach and education will be probably the most effective implementation tool that the agency has here. And I believe there is an appropriation here to assist with that, with that effort.
Okay, so let's set that for now and keep going, because we're getting pretty darn close.
Page 62, lines 3 through 6, there's a disposal requirement and there's irreparable polystyrene. You have to dispose of it in an approved manner. I have to go soon,
Yeah.
but I would like to flip ahead to the second to last section of the bill. Because I don't know what this means. 27. This is language that I believe was proposed by the department. And it says notwithstanding the requirements of this chapter, and so you're in the chapter for the standard agency notice and comment provision, so notwithstanding those requirements. During a federally declared emergency or a state emergency issued in response to a natural disaster, the secretary may issue certain individual permits and notice of intent under general permit as emergency permits according to the procedures established in section 7716 of the title. I don't know what the intent of this language is. I read it as they're giving themselves the ability to issue any permit without going through notice and comment as an emergency permit. Now, the governor already has emergency permit authority under Title 20, Chapter 1, to issue emergency permits. Let me find it. A consultation with the Secretary of Natural Resources to authorize the agency to issue temporary emergency permits with appropriate conditions to minimize significant adverse environmental effects after limited or no opportunity for public comment, allowing safe preparation for construction, etc. It goes on. I don't know what this is for.
Because it's already provided for in those respects.
The governor already has emergency permitting authority. Title 5 sets out the Type 5 procedures in 7716 set out what they can be used for. And then I don't know what a natural disaster is. I don't know how long the state of emergency declared by the governor lasts. I don't know what it means only for activities that are necessary to respond to the conditions created or caused by a natural disaster, to conduct hazard mitigation, and then support response and recovery efforts. So the governor's declaration of emergency for the July flooding expired, and they were continuing to implement response and recovery efforts. Would they be able to issue emergency permits after the declaration of emergency has expired? I don't understand this language at all.
Can they be retroactively issued?
Well, there is no retroactive clause in this bill, so everything is prospective under the default. I'm getting texted to come to.
So, as Mr. O'Grady's packing up, can you offer any answers, like what the rationale for doing this is compared to what already is in existing law?
During the summer, a number of executive orders were issued that this is essentially suspended permitting requirements. The agency wants the opportunity to review the projects on a streamlined fashion. I do hear Mr. Brady's concerns, and I can take a second look at this language and come back to it, but the idea is that we have the ability to quickly issue authorizations, but still maintain permanent jurisdiction over those projects.
This is when a village is isolated, the guys working on the roads are told more or less do what you have to do.
Thank you.
I'm not gonna go this later.
I do, this does limit it to during a federally declared emergency or state of emergency. I believe it's the time limited, but yes, in those instances where.
So,
Although the drought streams, west, east of Patriot Village.
Senator White,
Thank you, Mr. Chair. Personally, I'm not in favor of us including this language in here, and Senator Watson and I had a brief conversation about it as well, and I know she has some concerns.
yeah, this was often when the agency says, we have some language, we want housekeeping language. This is not exactly, we were talking about housekeeping language before we started this morning, so this is beyond housekeeping skills, I think.
Perhaps, yeah.
Correct. Our council suggests, the review of our council suggests to me that's beyond housekeeping, but, if you can. Maybe, could you follow up directly, Mr. O'Grady? Because I think lawyer to lawyer, you'll be able to explain what makes sense to you. You're both sensible people. So if something makes sense to you and it doesn't make sense to him. So I wish I could be there for the conversation, but it would be great if you guys could talk. And then we'll check in with the two of you.
Yes, I can do that.
Okay. So with that,
So are we not including it?
I would say,
Hold it in the veins.
because it's hanging for the moment, I mean. Just like the other thing, I only wanna ask council to put in or out once and where
But it seems like you've added this. So without, so my,
Yes.
within the last draft,
It's-
we did not review it. Okay. So we did not get to it, so I guess my concern is that we are adding something into the bill that we as a committee have not fully discussed.
Yes,
Well, we're not adding, yeah.
He is telling us it is added.
okay, so I would say, here's the chair's discretion thing, I'm fielding requests from like 12 people.
Yes.
So for the most part, if it makes sense to have, it potentially included, it's way easier, my experience, to put it in. See the actual language is supposed to have an idea, someone says, we'd like to do X, Y, Z. Put it in, review it, and then always, anything that, the reason it's highlighted is to make sure that it doesn't sort of float into the bill and someone.
Yes.
So,
So since we did not have time yesterday to look at it. I would have brought up, I would not have wanted it for inclusion, we did not get to it, so today I am saying I do not think that this should be included further in the bill. And I also know that we have colleagues who have concerns about this section, what I'm hearing
Wait.
is that you are
if you,
going to.
yeah, if you
into
can
this.
document those concerns, that will be helpful. I mean, I don't understand. So I'm asking the lawyers to parse it and report back. I don't have the
But
legal,
we're gonna keep it in.
Highlighted.
you need, yes, it's highlighted, it's grayed out.
Keep it in highlighted.
Okay.
It's because otherwise, if I said, oh, we have concerns, take it out. Then, and what if I'm not, I'm making no judgment as to where we land. So if then we said, oh, this, now that we fully understand it, it makes sense, put it back in. I'm commiserating with drafters who have to like keep track of stuff, they put stuff in, they put the take stuff out, I don't wanna ask them. Till we've reviewed it and agreed upon it as a committee,
You wanna keep it in.
just leaving it.
Okay, I think my only concern was that we,
It's not gonna just flow through as we don't get to it, we're gonna have review times tomorrow. And we're gonna vote on Friday, and the reason we have to vote Friday is because Mr. O'Grady is completely booked for tomorrow, and we also only have half the morning because we have US assemblies. So I figure we'll try to get a clean draft for tomorrow of the numerous things we ticked off today. We won't have counsel with this, but I think we can go back through them and say. With everyone but the lawyer, our lawyer present, yes, no, makes sense, good, still have a question, and we'll. Here's how many flags I have on my copy. of
Yeah,
today,
And this just seems like an easy
and
take.
my goal is to, reduce that to a small number, and on Friday. Deal with the final flags, and I have no dog in this fight. 27 in, 27 out, I just want to hear from the lawyers. Before we make a decision. Cause I don't really, if Mr. O'Grady doesn't understand what it does and why and how. And I'm way behind him.
Yeah, I think it's just a process point, so we just need to get to it, yeah.
We didn't get, I expect to join you in wanting this out. You know, there's a conversation we haven't had yet.
Yeah, exactly. So then I think I think maybe in the future when we draft legislation, we should discuss why it should be an opt-in versus an opt-out for inclusion instead.
Sure. And. Yeah. And you know, where it comes from is, me having a keen sense of. How, we can only get limited, I can only get limited time with Mr. O'Grady and stuff, so when things come along. I tend to put them in and say, then they'll be ready to go if we want it, if we, taking out is always.
Okay.
Yeah, that's it, so we have gone, 11.